All right, let me say good morning and welcome to everyone joining us this morning, both those here in the Office of the Prime Minister's press room. We are using our facilities this morning to accommodate a briefing of government senators. So we want to welcome our three government senators who are at the head table. From my immediate left, Senator Mark Golding, Senator and Information Minister Sandra Faulkner, and Senator A.J. Nicholson. The briefing this morning, we will hear first from Senator Faulkner, who will make a statement, and then we will open the briefing, and then we will have other statements from the other senators. I want to recognize also in the audience our other senators who I am sure Minister will introduce, and appropriately so, in a while. At this stage then, let me welcome you. We are streaming live our briefing, and we want to welcome our viewers on the internet. Over to you, Minister.
Thank you, Lincoln. Good morning, everyone. We want to welcome our viewers on the PBCJ and those joining us on the World Wide Web. As Lincoln said, this is a briefing of government senators, and he already introduced my two colleagues who are sitting beside me, and we also have Senator Lambert Brown and Senator Sophia Fraser-Binns here with us, and we want to welcome you. On Thursday, October 22, 2015, Senator Malahoo Fort, in her presentation on the Caribbean Court of Justice, read into the records of the Senate a letter which she claimed confirms the willingness of the Privy Council to sit in Jamaica. This letter was allegedly addressed to the then Minister of Justice. The Minister of Justice, Senator the Honorable Mark Golding, informed the Senate that the ministry, after an exhaustive search, was unable to locate any such letter in its registry. Both the President and Senator Golding requested a copy of the letter, and the President further directed Senator Malahoo Fort to provide the Senate with a copy. She left the sitting on Thursday without submitting the letter to the Senate. On Friday, October 23, 2015, at the start of the sitting, the President again instructed that the letter be provided to the Senate. Senator the Honorable Mark Golding then indicated that he had also emailed Senator Malahoo Fort the evening before, reminding her to furnish the Senate with a copy of the letter purportedly from the Privy Council and addressed to the Office of the Minister of Justice. The Minister once again asked the President to use his good offices to secure the letter in question. It was therefore very curious that Senator Marlene Malahoo Fort told the President that she was unable to locate the letter, which must be among her papers. The President repeated his directive that the letter be provided to the Senate that day. Sometime in the afternoon, Senator Malahoo Fort left the chamber and later sent a male orderly to retrieve her bag. On seeing this, the leader of government business, given the previous deflections on an important matter, was concerned that the senator may be leaving the Parliament without producing the letter. As such, Minister Nicholson alerted the President and asked that the senator be requested to return to the chamber and provide the letter. The President instructed the Marshal to ask Senator Malahoo Fort to return to the chamber. On his return, he told the President that Senator Malahoo Fort said, and I quote, "Message received." As the Senate was nearing adjournment, the President again asked the Marshal to request that the senator return to the chamber. On his return, the Marshal said Senator Malahoo Fort told him that the President could proceed to adjourn the sitting as she had already given her undertaking to provide the letter. It must be noted that on the two occasions she was still in the dining room and not in the restroom as is being alleged. In accordance with the rules of the standing orders, the President proceeded to name the senator, and the motion was moved and carried for the senator to be suspended until the letter is provided to the Senate. It is interesting to note that Senator Malahoo Fort returned to the chamber before the President departed and made no effort to present the letter or engage him in any way. There are some questions which now arise. What is in that letter that Senator Malahoo Forte and her colleagues cannot afford or allow the government senators to see? What is contained in the letter that a senator would prefer to be suspended rather than allow the government senators and the public to see the content? Why is there a difficulty in producing copies of a letter to the President, the Minister of Justice, and by extension the Senate? At the same time, the senator was reading the letter, allegedly from the Privy Council, into the records of the Senate. Why is there no trace of that letter purportedly written to the government of Jamaica in the Ministry of Justice or the Ministry of Foreign Affairs and Foreign Trade? Why is it that so much is being made of a suspension until a copy of the letter is produced? The suspension will be lifted once a copy is produced at the next sitting of the Senate. Would that not be simply the end of the matter? It is curious that rather than obey the instructions of the Senate President and produce the letter, Senator Malahoo Forte chose suspension. Many yarns are being spun to deflect from the primary issue. Why this deflection? Why not just produce the letter? Again, I repeat, what is in this letter? Is it authentic? We would wish to find out whether or not the content of the letter addresses the public assertions of the former Minister of Justice, Lightburn, that there is no cost to appeals to the Privy Council. Stripped of everything, is the public not entitled to know the content of a letter that a senator on her feet refers to as a pivotal piece of information that is germane to the proposal that the people should be able to enjoy greater access to justice? We are anxious to find out. I now turn to my colleague, Senator Mark Golding.
Thank you, Senator Forte. Ladies and gentlemen, I think it's very important to recognize the fact that the letter that was read to the Senate by Senator Malahoo Forte last Thursday, and which she agreed to produce, but has not done so, is an official letter from the Privy Council to the then Minister of Justice, Dorothy Lightburn, and Attorney General at the time, in 2010. That is what our understanding is from what was read by Senator Malahoo Forte to the Senate. Her evasive conduct in over 2 days of sittings, consecutive days of sittings, failing to produce the letter as she indicated she would, and indeed as the President directed that she should, is problematic in a number of respects. First of all, it evidences a lack of respect for the Senate and for the President of the Senate and his rulings. But also, it's problematic because, from my standpoint as Minister of Justice, I'm anxious to see what this letter actually says. From our point of view, the Privy Council is not an itinerant court. It is not set up to sit outside of the United Kingdom. The judges who sit on the Privy Council are largely the same judges who sit on the UK Supreme Court, which are their primary duties. And they, although they have, it is true, occasionally sat outside of the UK, I believe they've done it in Mauritius and they've done it in the Bahamas. Those were ad hoc arrangements set up to hear particular matters, not to dispose of the entire list of cases that were before them from the Bahamas, and were indeed at great expense to the government and people of the Bahamas, involving the payment of first-class return tickets from the UK and back to the UK for the 5 judges and their support staff, obviously providing accommodation for them during their stay in the Bahamas, the security arrangements that they require, and, of course, the logistical arrangements of them actually sitting as a court there. We don't feel that those arrangements, ad hoc arrangements, whatever symbolic purpose they may have served, constitute proper arrangements for affording access to justice to a final court. The CCJ is established to provide access to the people of the region. Its rules contemplate it moving from territory to hear cases. It has heard a case involving an ordinary Jamaican, Shanique Myrie, and came here to hear that case. The Privy Council has never sat in Jamaica after 200 years or thereabouts of being our final court. Interestingly, the government of the day that received that letter does not seem to have done anything about it. We have heard no arrangements for, being contemplated for the Privy Council to come and hear cases here. In fact, we weren't even aware of this letter from the Privy Council to the Minister of Justice until very recently. The question arises, why was this offer not taken up? What were the costs that would have been incurred were it to be taken up? It's perplexing, is all I can say. But there's more to it than that. The reality is that this letter has been held forth by Senator Malahoo Fort and others as suggesting that we should stay with the Privy Council. When I heard the letter read into the record, it was noteworthy to me that apparently the arrangements that led to that letter being written by the Privy Council were in some way intermediated by the law firm in London that represents the government of Jamaica in Privy Council appeals. That law firm clearly has a strong financial interest in continuing current arrangements for Jamaica, where we have to engage solicitors in London as Privy Council agents to brief counsel and file papers and so on for matters that are heard in London. Indeed, that law firm has earned fees of some $207 million over the last 5.5 years from providing those UK Privy Council appeal services to the government of Jamaica. None of that was disclosed by either the Observer or Senator Malahoo Fort. But the fact is that the initiation of that letter appears to have been or involved a firm that has a very strong financial interest in Jamaica remaining with the Privy Council. I reiterate to the public that ad hoc symbolic arrangements at considerable cost, whereby the Privy Council may at times convenient for them as they dispose of their busy schedule as judges of the UK Supreme Court, is not acceptable access to justice for our people, access to our final court. We want to move to the CCJ, which is set up to ensure ready access. Caribbean citizens have a right to travel. They don't need a visa to travel around CARICOM. If they wish to go to the CCJ in Trinidad, which is the seat of the court, they have the right to do there at a cost which is significantly less than traveling to London where they would require a visa. And in any other case, the CCJ is set up with audiovisual and ICT facilities as part of their procedures so that they can hear pre-trial matters, which are a significant portion of any case going to an appeal, without counsel or litigants having to travel. The Privy Council, in contrast, does not facilitate that currently. And the filing fees, as I said in my Senate presentation, to file a case in the Privy Council were increased in 2013 and range from 70,000 Jamaican dollars to close to $1 million Jamaican just to file a case in the Privy Council. Whereas the equivalent fees are a flat fee for the CCJ of some 7,500 Jamaican dollars. Accessibility is at the heart of this matter. This letter is a red herring, and I call it Lettergate. This is Jamaica's Lettergate, the equivalent to the US Watergate. In my opinion, the opposition need to produce this letter, which apparently they have, which is an official letter, without any further delay. And I think it's quite proper that Senator Malahoo Fort has been suspended from attending the Senate until she does so. Thank you.
Minister Nicholson.
You know, I've had reason to say recently at a symposium at the University of the West Indies that this journey of Jamaica to move away from the Judicial Committee of the Privy Council to another court, really it is for me not only an interesting journey, it's almost a magical journey. This is just another blip on the journey, albeit a very important blip. But we will overcome. It's just another blip. You would have noted that I didn't personally answer Mr. Chang. All I will say to him at this point in time, that he should have made further and better inquiries before rushing to the press about bathroom break. That's all I will say to Mr. Chang. The opposition is frazzled.
By this letter gate.
They are conflicted. They know that they are supposed to vote for the bills. It's the right thing to do. They know that. The measure seeks to empower some 99% of our people. If any one of you, journalists, is a parliamentarian, and somebody comes to you and say that we wish for you to vote for a measure that is going to give some privileges and benefits to 99% of your people, what are you going to say? And the only way you are not going to vote aye is if something or somebody is holding you back. The senators are frazzled. They are tormented. Why? The crushing weight of the mighty weight of the continuous stream of endorsement from so many sectors of civil society, of the entire society, must weigh heavily on them. I forgive them, as a matter of fact. I forgive them for what they have been trying to do to me. I forgive them. Why? Because I know that they are tormented. They don't know what to do. The overwhelming evidence points towards a yes vote. Even Mr. Chuck is confused. Simply confused. He's upset. He's in a frenzy. He's behaving in an ornery way. He's ornery. Between his leader and himself, threatening the opposition senators. You really think that is what the Constitution of Jamaica should lead us to do? Threatening the consent vote of a senator, telling us that they are going to withdraw from the Senate. Look, how on earth can a leader of a party, leader of opposition, or prime minister tell senators that they must not go to the Senate? You're in a frenzy. You're frazzled. You're tormented. Not only that, Minister Golding refers to this as lettergate. Every time letters come up for the opposition senators is problems. Look what a letter, the mere copying and handing over of a letter, look what it has caused. Over 2 days. How long does it take to copy a letter? You don't hand it over. And the truth is that the opposition and the opposition senators are not getting much traction from anywhere else in the society. I hear a couple of radio stations, giving some light support to them. But that is, dear. The best support seems to be coming from the Observer. Until recently, the Observer newspaper, daily newspaper in Jamaica, was the most strident supporter of Jamaica moving to the CCJ. What happened? After a case was lost in the courts here, we hear something different. And we know what instructions were given to persons who work at the Observer, what instructions were given on an aeroplane. We know. But it doesn't stop there. The Privy Council shocker, according to them, in a front page, that's stale news. Stale news. The leader of the opposition referred to it in his contribution to the CCJ debate in the House of Representatives. Others, including Mr. Siaga, have written about this, but that has been addressed by the Minister of Justice. All these conditions that they are setting down, this Assistant Registrar of the Privy Council setting down to come here to hear cases in sunny Jamaica. The CCJ, they don't have those conditions, they just come. We don't stop there. They produce, as the Observer, produce what they call a front page editorial on Friday. It's a prime example of why no country has ever had a referendum on this matter. Prime example. Because what they said in that editorial, really, as far as I'm concerned, it is contemptuous of the judiciary in the Caribbean. What did they say? They said that corruption, cronyism, school ties, business and familial bonds, these connections and links, which sometimes stretch from Jamaica to other islands of the Caribbean, too often conspire to determine the outcome of cases. Who is writing that to tell the world that we have corrupt judges in Jamaica and in the Caribbean? How dare the Observer do that? That's totally wrong. You have criminals everywhere and you have good judges everywhere. But you don't link criminality to your judiciary. And as a national newspaper, you project that to the world. But it doesn't stop there. They ask in that editorial, but where did you get the authority to be taking our highest court? No. Where did, front page, where did you, how dare you appropriate the people's rights unto yourself? We are not appropriating the rights unto ourselves. The Privy Council told us, told all Jamaica, told the world how you move from the Privy Council to that court. How dare they tell the Privy Council to go to hell? Because that's what they are doing. In the same way as the Minister of Justice or the Attorney General cannot go to the Parliament and say you must pass this bill by a simple majority. It isn't because they are obeying the rule laid down by the Privy Council. In the same way, you can't tell the Privy Council to go to hell with your judgment, we want a referendum. Lastly, the press should know, and the people of Jamaica should know, that there's no dichotomy. There is no incongruity with feeling that what is required is a referendum on the one hand and voting for the bills. There's no dichotomy. As a matter of fact, in almost every country, certainly in Canada, when this thing happened in the 1930s, move away from the Privy Council to the Court, in New Zealand recently, and probably everywhere that has happened, you would have had parliamentarians who felt that there should be a referendum. But that's their private view. That's their political view. That's their party view. That is they and their friends' view. When a bill comes before the parliament, there are 4 things that a parliamentarian, a legislator, is to take into account. 1, is the bill unconstitutional? If it is not unconstitutional, you go ahead. Does the bill offend against public morals? It doesn't, you go ahead. 3, is the bill in the interest of the people of Jamaica? In this case, this bill is in the interest of more than 99% of the people of Jamaica. And 4, does the bill offend any international treaty or convention or agreement? If the answer is no, you go ahead. Those are the 4 things that you take into account. So, if the answer to those 4 questions push you in a positive vein, it doesn't matter, you vote even though deep down you think that there should be a referendum. And that is what has happened in Canada, in New Zealand, in Australia, everywhere, including perhaps in Belize, in Barbados, in Dominica, everywhere. There are persons who are going to have their private or political view, but you can't use that to keep back the movement forward of your people. Now the senators know that. The 8 senators know that. All 21 senators know that. Those 8 senators are conflicted. They are tormented. I would encourage you to pray for them. Why? Why? If they don't vote for the bills, they are going to live with that torment for the rest of their lives. Because they know that they will be holding back benefits from their people. We approached this debate so far with Minister Golding and Senator Knight setting the foundation, the legal foundation, and the practical nature of why you should move from the Privy Council to the CCJ. Then we put forward the youth view, the youth in the person of Senator Fraser Binns, asking all the senators to vote in a certain way to give a chance to young people to come up. To be very few persons, very few attorneys get a chance to go to the Privy Council. And then we had Senator Skeffrey. We had Senator Skeffrey telling us why the national heroes, our national heroes, are egging us on to move in the direction that they had gone. They are tormented. We have to help them out of this. Something or someone is holding them back. Why should Mr. Chuck be threatening his own colleagues, senators, that if you vote for it, we're going to Privy Council or we're going to court? Why? It's only a tormented soul says these things. But again, I say the journey has been it's a golden journey. A journey, not many things have happened in Jamaica that have been so interesting as this journey. This is just another blip. Please.
We open the floor for your questions. One question, a follow-up, and we'll pass it around. Dara? Good afternoon.
The government senators are saying that Marlene Malahou Fort will not be accepted back in the Senate until she produces this letter. The opposition senators are saying that they're going to boycott the Senate sittings until she's reinstated or until the suspension has been lifted. What does this mean for the debate on the CCJ?
Well, look, Minister Faulkner said it, All you have to do is come to the Senate and give the president the letter and everything done.
And she said twice. She said it on Thursday.
Done.
And she said it on Friday that she was going to do it.
Done.
She said it as if it was no big deal. So I sent her an email on Thursday night to remind her of that commitment. In fact, the email string that email was part of from me to her was an email where I had sent her a copy of my presentation at her request. She had asked me for a copy of my presentation. And I'd emailed it to her, and she had acknowledged receipt of it. And I clicked reply on Thursday evening to that and said, Marlene, please remember to provide the letter. We want to see it. She never replied to that. But on Friday morning, when the president said to her, reminding her that she had said she would give it and she should produce it that day, Friday, she said she would. She had said she couldn't find it among her papers. But of course, she found it because wasn't it produced at some JLP meeting over the weekend? The same letter? So, I mean, all this letter is rife in JLP circles now, but why can't the Parliament of the land get a copy?
And that's my question. Yeah. What if she doesn't produce
this
document?
I know. Look, understand this. If the JLP want to boycott the debate, you can't stop them, You can't stop them. If they want to boycott the debate and don't want to give to the 99% of Jamaicans some access to justice, they can go ahead, live with it. We can't force them. But as I say, it's an easy thing to do. Just come, hand in the letter, and we go on. As a matter of fact, the suspension really is a nothingness, so to speak. Why do I say that? The suspension is until you produce a letter. Right? Well, all you have to do is come to the next sitting of the Senate and produce a letter. You really wouldn't have been suspended, would you?
It would be a real shame if the opposition were to use this letter gate to close the gate on justice for the people of Jamaica.
That's right.
Are we going to continue with the debate if they don't?
No. That we sufficient unto the day.
Yes.
Sufficient unto the day. One thing though, I would advise the opposition senators to return. I would advise them to. You remember how I started? Let me remind you. The bottom line in all of this is whether there was a bathroom break or a lunch break. That's the bottom line in all of this. All we're going around the bush asking questions about whether they're going to boycott. Look, if it is, all the evidence points to a lunch break. All the evidence. Even the newspapers, the Observer itself, Mr. Balfour Henry, the lunch break, they were in the lunchroom. Everybody has pointed that what's his name, the marshal.
The marshal.
Everybody, the lunch break, in the lunchroom. Not at all about any what name? Bathroom break. If that falls, if that assertion falls, the Jamaica Labour Party will have to answer to history for that lie.
And I think it is also very important for us to recognize that Senator Malahoo Fort was extremely disrespectful to the President of the Senate, who gave her not only one instruction for the letter to be presented, it was done over 2 days. And the fact that she has not presented the letter to the Senate, and that is the convention in the Senate. When we read something into the record, we normally share a copy with the Senate. And the fact that she hasn't done so shows a tremendous respect for the institution of the Senate and the President of the Senate. And that's unacceptable.
And her behavior in this matter has been very unsatisfactory. I mean, on Thursday, she described the process of being embarked on by these bills as a mockery of the Constitution. I objected to that statement because the process being followed by these bills is the process that the highest court, the Privy Council, has said should be followed. These bills must be entrenched, and we are entrenching them in the Constitution. Mr. Chuck seems to have dropped the ball on that over the weekend. He doesn't seem to understand how the bills work. But that is what is happening.
He's frazzled.
So she was asked to withdraw that comment about this being a mockery of the Constitution. She declined to do so. That nearly resulted, and that was a violation of a ruling by the President. That could easily have resulted in her being suspended. I had to ask for leniency and mercy towards her conduct, even though it was contemptible conduct. And leniency and mercy was indeed shown. This was Thursday. On Friday now, having agreed to produce a letter, she doesn't produce a letter. And when she's asked to return to the chamber, she says, adjourn the proceedings. She leaves, that's the message she gives to the marshal who's been asked to ask her to return. I mean, this is absolute disrespect towards the President of the Senate and the Senate as a whole. And I really don't see why the opposition should be countenancing such conduct. If I was behaving in such a inappropriate and unsenatorial way, I know the leader of government business would be all over me to set me straight. And that's what we expect of the leadership in the Senate and of the other senators. She's erred. It's quite clear she's erred. A
Minister,
quiet word to her should be sufficient. Don't use it as some kind of political opportunity to make a huge fuss about something which is quite elementary. This letter ought to be produced. Produce it. You have it. Produce it.
Edmund?
yeah, Minister Golding, notwithstanding the issue regarding the letter surrounding Senator Malahoo Fort, I'm just wondering whether your ministry, whether you could not make a request to the Privy Council, for example, because somewhere in the records there, they probably would have a copy of the letter.
We're going to have to. When this letter only came to my attention when the Observer published its article, this Privy Council shocker thing, on Wednesday. I wasn't aware of that letter before. And when Senator Malahoo Fort on Thursday produced it in her hands in the course of her very lengthy presentation, and indeed read it and was asked to produce a copy for the Senate and said she would, I took her at her word. I didn't think this was a big deal. This is something that happens all the time in the Senate. If you're reading from a document and members want a copy, you produce a copy. That's courtesy and convention.
No, but it's the only way you're going to know if you're speaking the truth. You might have a blank piece of paper.
There you go. So I'm still expecting my colleague Marlene to produce a letter like she said she would. I'm sure, over a lot of more heat than light has been produced in this matter. But I hope that when the heat calms down, some light will come through, and she'll simply produce it. If she doesn't, I'm obviously going to have to ask the Privy Council if they can find from their records and produce a copy for us.
You think that's the kind of action that is required of a parliamentarian to cause a minister to have to go and write letter to London to get something when you say you have it in your hand?
Minister Golding made a decision which he just spoke about on Thursday. He asked for leniency so that, the Senator Malahou Ford would not be suspended and that the debate would continue. And we understand how important this debate is to the country. What I'm seeing here is a situation where it is obvious that this issue is going to present a serious problem for the continuation of this debate based on earlier comments. No, I'm just suggesting, Senator Nichols, I'm suggesting, could we, in going forward, take the approach of trying to get a copy of the letter from the Privy Council and waive the suspension that was issued in Parliament, in the Senate, to Senator Malahou Ford, in the interest of allowing this very important debate to continue.
But wouldn't you think that is really countenancing utmost contemptuous conduct for the rulings of the President of the Senate? What kind of precedent would that set for the future? I mean, the Senator had strayed on Thursday. Leniency was shown on Thursday, for the very reasons that you have outlined. On Friday, the non-production of the letter over a period of 2 days reached the point where the President named her and say you're suspended until you produce it. If the Senate waives that, what kind of message does it show for future conduct of senators in obeying rulings of the President? I'm not saying what will happen, because clearly we all want this debate to continue in a collegial and mature way, and hopefully arrive at a result that moves Jamaica forward. But in saying whether this some kind of waiver of the suspension is going to take place, we would have to think very carefully about that. And it's not up to us anyway. It's the President who made the ruling.
Abco?
Abka Fitzhenley, Nationwide News. Question to the Justice Minister. Very good morning to you, sir.
Morning, sir.
This letter that was read in Parliament, I have before me, and it indicates that Lord Phillips and Lord Hope would be delighted to visit Jamaica to have consultation regarding future sittings in Jamaica. It outlines costs. The letter is basically on the letterhead of the Privy Council. It comes under the name of the Acting Registrar, Louise de Mambro, but it is not signed, I note.
It's not signed?
In terms of the substance.
That's interesting.
Give us a copy.
It's not signed. You're lucky you have it. We haven't been able to get it.
I don't know where you're reading from. No.
May I proceed with my question, sir?
Just a minute. I don't know what you are reading from. It might be a blank piece of paper. Give me a copy.
The question is directed to the Justice Minister.
No, you don't care who it's addressed to.
All right.
And, Minister, the question is, sir, this business of the Privy Council indicating a preliminary willingness to have discussions towards sitting in Jamaica, does it affect at all the point you made, one of the main pillars of the CCG about access?
One second, Mark. Before Mark answers, though, you did indicate that the letter is not signed, right? The letter from
based
which
on
you're
what I've
reading,
observed.
that's not signed. Okay, I just want that for the record.
Okay, well.
So we don't know that it's authentic either.
If you have a copy and you can shoot it to me, I'd really appreciate it. I'd love to see it, you know. But anyway, the short answer is no. Well, Lord Phillips and Lord Hope are both retired, by the way. They're no longer on the Supreme Court of the United Kingdom, and they no longer really hear or adjudicate cases. But that aside, do I feel that this tentative offer of a willingness to come and sit, to visit Jamaica and hear cases should derail the process? Absolutely not. The Privy Council is a colonial court set up to sit in London. Its judges are, although occasionally it will, if a judge from the jurisdiction where the case comes happens to be in London, and he's a senior judge, he may be invited to sit on the panel. So from time to time, we've had situations where I think Justice Zaka sat occasionally on the Privy Council as one of the 5 judges and so on. But for the most part, it is the same judges that hear English appeals. They have a heavy load of work to do, and they have said that to me in person, because I've met them. I've visited the Privy Council in London. No mention, by the way, when I visited of any such offer was made to me at that time when I was there in February for the Magna Carta 800th anniversary summit that they kept in London. The fact is, it is not established to sit as an itinerant court. It could not in practice visit all of the little territories around the world which have appeals to the Privy Council, whether it be in the Caribbean, the Falkland Islands, in the Pacific Ocean and Indian Ocean. It is not practical. They may occasionally visit if you pay their costs. We can't have a final court that operates on that basis. We need a court which is accessible to Jamaicans in a structured way, which is what the CCJ was set up to do. And it's both from the use of technology, also from the fact that there are no visa requirements for travel, and because the court itself is set up to visit and has visited Jamaica. So while I would welcome a visit by the Privy Council if we could afford it, I don't know what the cost would be. I suspect we couldn't afford it. But if we could afford it, I have no objection to the Privy Council visiting here, but that would not be, in my view, an indication of any kind of arrangement that would enable me to say with confidence to the Jamaican people, we must stay with this British court that sits in London, because from time to time they may come here or they may not. We have set up a court, we have funded the court, it's an excellent court. It has a track record which Lloyd Barnett himself has said is enviable and is laudable. We must give the right to our people to use it. And simple as that.
Let me make a comment on that. Look, let us not forget, that the same Lord Phillips that you mentioned, when he was exhorting us to use the court that we have set up, because his judges are wasting time on matters on which they don't have any interest, we tend to forget that he said that judges of a lesser standing than those who normally sit in the Privy Council and the House of Lords should be employed to sit on our final cases.
And that's problematic, because then you have the possibility of Court of Appeal judges of the UK hearing appeals from Court of Appeal judges here. And that would be, to my mind, would undermine the tiered system of a final court.
Minister Nichols.
1 second, Edmund. Can we allow the microphone to go around?
With respect, Senator, be allowed my follow-up? As that
I thought you had your follow-up already.
No, I did not.
But go ahead. Sorry about that. Go ahead.
Thank you, Senator. I understand, Senator Golding, the position of the government side to be that when the letter is turned over to the custody of the Senate President, the Senate, the suspension will be lifted in relation to Senator Malahoo Fort. I'm advised that this morning a copy of the letter was dispatched via email to the leader of government business in the Senate and also to the President, Floyd Morris. Seeing that development has in fact occurred, does that now pave the way?
Don't say has in fact, because we don't know if it's fact. Say if it has occurred.
Well, I'm advised that it has. The email was dispatched this morning and a hard copy correspondence is on its way to the respective offices. Does it now stand that if in fact that has transpired, the suspension will be lifted?
Sure.
Is Golden is asking?
Yes.
You want me to answer it now?
I'm happy to answer it. But if
you can't answer because I got the email.
Yeah?
Look, I got the email.
Oh, okay.
The answer to that letter that we're talking about. All you got to do is present the letter to the President. Full stop. Done.
But the standing order says that a senator is not allowed, when suspended, is not allowed in the precincts of the Parliament.
Don't spin wheels. If the President suspends you until you present the letter to him, and you tell the President that you have the letter, the President will simply send for you, regardless of what the standing orders say. They'll send for you and give it a letter, and give him the letter, and we'll resume. Why are we making a mountain out of a molehill? Just bring the letter, come. If they come in the precincts of the court with the letter, You really believe that the president is going to run them? He what? I don't hear you.
He said, ask if the email doesn't suffice.
No. There is no email about the letter, you know. The letter that you say read it from now.
Oh.
There's no email about that letter. The email is about the same thing that you asked, that you can't come in the precincts of the Senate because you have suspended me.
Oh.
No, man, I'm advised the letter was sent to you.
No. I haven't got any letter.
You haven't gotten it?
No, I haven't
All
got
right,
no
fine.
All
But
right.
look, I can assure you, our interest is to resume the debate,
That's right.
and our interest is to
quickly as
have the
possible.
letter. If the letter is produced, we have no interest in maintaining any suspension of Senator Malahoo Ford. We want her back.
Edmond, we're going to allow others who haven't had a chance yet, and then we'll come back to you. Dara, you had a question? Okay, anybody has a question? We'll just go to Edmond.
Final
then.
issue.
Yes.
Minister Nicholson, you chided Delroy Chuck earlier for comments he made, and you insinuated that he was demented.
No.
Or tormented for
Tormented.
Tormented.
Two different things.
Tormented.
Please.
Correction, tormented.
Two different things.
I know what you said.
You might know something I don't know, but tormented.
No, Minister, I want to find out.
Yeah.
On the issue of Mr. Chuck threatening, quote unquote, his colleagues not to vote with the government side for the CCJ bills. Isn't it the case, Minister Nicholson, that for the most part, that parliamentarians, whether in the lower or upper house, notwithstanding this talk about voting your conscience, isn't it the case that most parliamentarians vote along party lines?
No. All right. I answer that question for you, you know. You remember when I was discussing the matter of the referendum? It is the party line, for example, of the JLP that you want a referendum. It's a party line. But you remember the 4 conditions that I lay out for you. If they are in the positive, you remember? The interests of the public, it's you're not against public morals and the like. Right? Remember I say, there is no incongruity between wanting a referendum and voting for the bills. There's nothing wrong with that. I'm not telling anyone who gets up on the other side and say that I would prefer a referendum. There's nothing wrong with that. I prefer a referendum. But to give the people what they want, you can't hold out your personal feeling and your political feeling, your party feeling, to deny the people their rights. Would that be fair? Really, you think Paul Bogle would want you to do that?
Darrow?
So you've hinted that it was the copy that APCA had was unsigned.
No, he said that.
He said it, no.
He said it.
It was unsigned.
Yes.
What does it mean for admitting such a letter in terms of to the Senate President, if it is that it's unsigned?
It shouldn't be referred to from that at all. If it is true, it's unsigned, you know. That's why we have to see it. Because really, if it is unsigned, you really now come in to speak in an authentic way that the Privy Council has made an offer to the government and people of Jamaica that we will come to Jamaica. How
Yes.
it's unsigned there, how we know
That is authentic.
that letter, and somebody just sit down, get a letterhead for the Privy Council and write that down.
But, you know, if it's unsigned and I get a copy, I'm going to have to further investigate its authenticity, which I will. You know, obviously, I mean, I'll be more surprised if the Observer and
Good God.
Senator Malahoo Ford et al. Have been relying on an unsigned letter. But, you know, who knows? Wonders never cease.
All right, we take one more question. We have cabinet, so we want to wrap up. Abco?
To ask quickly of Senator Nicholson. The opposition, they have issued a press release indicating that they will not return to the Senate unless an apology is forthcoming from yourself and Senator Floyd Morris to Senator Malahoo Ford. Your response to that, are you willing to do so?
The crux of this matter is whether there was a bathroom break or a lunch break. If there was no bathroom break, there was nothing for me to apologize for. I don't know about the president.
Well, now that you say that, I just wish to ask very finally that it's been reported in the public domain, and basically a side issue you may see it as, you were seen on camera directing the orderly not to carry Senator Malahoo Fort's handbag to her, and that has not been well received by some in the public domain. And I must ask you, as a man though, Senator Nichols, on what basis do you thrust upon yourself the power to issue a directive in relation to a woman's handbag as if you have superintendence over it? Why did you do that?
Well, that was merely to draw attention to exactly what was happening in the Senate. However, if you wish to take me to the task for doing that, I don't have a problem. But all you want is a letter. If you wish to take me to task, not a problem. Go ahead. Take me to task. Right? But we want the letter.
Ladies and gentlemen of the press, I want to thank you for coming at a short notice, and you have come in your numbers, so thank you. I want to thank our viewers on the PBCJ and those joining us on the World Wide Web. Have a great day.